My name is Chuck Dick. I have the privilege of being one of the co-chairs of the programming committee for California arbitration. And one of my responsibilities is to host a series that we call California Conversations. And I'm glad today to be able to continue our collection of interviews with notables within the profession here in California, particularly because Steve Cologne, our guest today, is from San Diego, a longtime professional colleague of mine. I've known Steve for longer than I think I can count on as many hands, and I'm delighted that he said yes when I asked him if he would consider joining us for California Conversation. So welcome, Steve. I'm delighted we can include you in this program, and welcome to California Conversations, as I say.
Good morning, Chuck. It's a pleasure to be here. Thank you again uh, for interviewing me and having a California conversation with me. Happy New Year to you and your family as well.
Steve, at the risk of embellishing your resume, I have to say you're clearly perceived in the local community as one of the notable trial lawyers. You've had a long and distinguished career. You're with one of the largest law firms in San Diego, and most recently actually wrapped up your tenure as the managing partner of that office and have returned to a practice that includes arbitration. So it's timely that we have a chance to talk to you a little bit about your career and what better place than to start and just say, tell us a little bit about how you got to where you are today.
Well, I have to tell you, Chuck, we all are a product of our mentoring, I suppose, in some degree. And I was very blessed to be with the top American college trial lawyers at McGinnis, Fitzgerald, Rees, Sharkey, and McIntyre. That's where I started as an associate. I didn't think I wanted to go into trial work out of law school. Thought I wanted to do land use planning. And I thought, well, everybody should do litigation. And if I don't like it in a couple years, I can do something else. Well, I've been doing trial work in state and federal court now for 39 years. And I've never done any land use planning. So I think I'm set in this type of legal work. I got into trial work immediately. They threw me to the wolves, as a lot of young trial lawyers my age got experience in, I hope. And I grew up in state and federal court doing very serious litigation, commercial litigation, a very high-end personal injury litigation, started doing trials on my own, absorbed the firm's clients that eventually, when I became a partner in 1991, became my clients. And so I thought my career would continue. I was blessed also to be invited to join the American Board of Trial Advocates. I've since obtained the rank of advocate, which is at least 50 jury trials to verdict. And I just kept enjoying my time in litigation, started having associates of my own, and really developed a pretty large practice. I then, our whole firm at McGinnis then moved in 1999 to Higgs, Fletcher, and Mack, San Diego's oldest law firm. And I got interested in law firm management as part of my obligations to the firm, and grew through committee work, through executive committee work, and then was voted in by my 21 partners to be the managing partner in 2016. And I served in that capacity through 3 terms, or 6 years. We have 2-year terms. Ended that in 2023, got the firm through COVID, got the firm through some very difficult management and ownership changes, but felt I really enjoyed trial work more than anything. And after 6 years in running a large firm, I felt it was time for others to have that opportunity. Not that a lot of people wanted to be managing partner, but I felt my time was done. And I went back to being a trial lawyer right away, frankly, in the fall and spring of 2024. And have enjoyed doing that. But a step back for arbitration, in 2020, I decided that I wanted to get into arbitration my father was an appellate court justice. I felt I had a temperament for deciding cases. I didn't think I ever wanted to be a judge in state or federal court, but I really enjoyed the commercial arbitration work. I had done that as a trial lawyer. I had done employment litigation as a trial lawyer. So I felt those two areas for arbitration were my strong suits. I got introduced to the Chartered Institute of Arbitration, which provided excellent training for international arbitration. It's what I enjoy doing. I met some great arbitrators, and I also was trained as a panel arbitrator for AAA. And surprisingly, was getting arbitrations right away. I spent a lot of time working on my resume, tried to appeal to out-of-town lawyers to hire me as an arbitrator. And I would say most of the arbitrations I've done, if not all of them, have been from out-of-town counsel, as opposed to where I'm mostly well known, which is San Diego. So I really felt that, and I couldn't understand why people out of town who didn't know me as a trial lawyer all these years would want me as an arbitrator. They may have asked their colleagues in San Diego, of course, but I think they felt that since I was the managing partner of a large firm, there were many people, my owners especially, who thought I could be fair, which I think is the bedrock for a good arbitrator. And so I accept that explanation until I'm told something else. But that's where I feel like I'm getting my most case assignments is through out-of-town counsel all across the United States. So from very large law firms in major cities. So for some reason, there's arbitration provisions in California, not necessarily venued in San Diego, but in California, they see my resume. I've been told I'm on a lot of strike lists and get hired for that reason as well. So I really would like it to become a larger percentage of my practice. And I think it's about a third of my practice right now. And as I get older and I see these young lawyers wanting trial experience as advocates, I will continue working probably for the next 10 years or so, performing arbitration work in California and international arbitration to the degree that's available for me as well.
You said several things here that I'd like to go back and explore, but one is the fact that you spring from a distinguished family in the local community, legal community, your father being a well-known name. And tell me a little bit about growing up in the home of a jurist such as your father, an appellate court judge, as you've indicated, and how that has contributed to sort of the value system that you bring to bear.
Well, my father started before becoming a judge as a lawyer. He was a legislator, California, state senator of California, was appointed to the California Court of Appeal in San Diego when I was 13. So I started high school with him as a jurist. And, he's the man I admire the most. With all due respect to the great lawyers at McGinnis that mentored me, he's the man who introduced me to the legal profession, what it meant to be an ethical lawyer, what it meant to be a perfectionist in your craft. And we've heard the adage, several of them, what goes around comes around, treating people with respect. He would describe oral argument. He would describe briefs. I actually externed at the Court of Appeal growing up. And we would go over what lawyers are doing, what briefs look like, what issues are being faced, how he would ask the right questions in order to gather the right data to make a well-reasoned, fair, impartial decision. And so all of that, as you can imagine, came through me as I was growing up in high school, college, and law school. And I knew from high school that I wanted to be a lawyer. So I took that information readily, and I was very grateful that my father, who obviously was with me in the home, would spend hours with me talking about being a judge, not to train me as a judge, but to train me in a people profession. And I do believe arbitration and the practice of law is a profession for people. We're not building widgets. We are interacting with people. We're relating to people. We're trying to understand their problems. We're trying to resolve their disputes. And I think it's important for your arbitrator to understand people, to relate to people. And that's what my father, I think, tried to help me do growing up. And he passed in 2019. I miss him terribly, but he did a great service to his children and me in particular by the
Mhm.
training and benefit that I got in my career.
Well, you also talked a bit earlier about your lengthy actual courtroom trial experience, both federal and state court experience. I wonder what about that kind of advocacy has equipped you to now, as you transition your practice into arbitration, to become an effective neutral, to understand, to be as fair-minded as you said you were.
Well, I've seen a lot of commercial, both business disputes, employment disputes. I've understood those issues. I understand the positions of the parties on those issues. I understand how the evidence is presented on those issues, what the arguments are going to be made on those issues. So I come to the arbitration table with a level of experience that I hope the parties see in an arbitrator someone who doesn't, it's not their first rodeo, and that they're able to assign weight to certain pieces of evidence that the parties try to present to me, that can ferret out arguments that are more persuasive than not, that can also evaluate the credibility of witnesses when I have evidentiary hearings, and can really assign a fair but experienced view of how business leaders and frankly individuals representing themselves are presenting their cases. And I think my trial experience has allowed me to be efficient, to be streamlined in the arbitration process, to see what is merit and what is meritless in the arguments that counsel make. And so I think if you have that trial experience, as opposed to an arbitrator without that experience, I do think you have a leg up in making a reasoned decision or a reasoned award that the parties can appreciate as just, comes from experience, and is fair. They may not agree with the result. Certainly one side is not going to agree with the result. But I want to come away from the arbitration that the parties, more than the counsel, see arbitration as an effective alternative to jury trials. And they can only gather that through the limited exposure they have to an arbitration. It may be the only one they ever have. But I want them to see that this arbitrator, namely me, handled it like a trial judge and formal. I wear a suit. I expect the parties to dress appropriately. They don't have to wear suits, of course, but I want people to see me as treating the process with some degree of formality, some degree of seriousness, not haphazard, not casual, not lackluster, not bored. I want them to appreciate that I see this as a very serious proceeding, and I expect them to do that. And I go over that with them at the preliminary hearing conference, or the first opportunity I have to speak to both parties, to lay the groundwork for what I see will happen throughout the life of the arbitration. And so I hope that they come away feeling good that they're going to get a formal, serious, understanding arbitrator who will listen to their case, who will ask questions where appropriate, and who will read the documents that are presented to them, and not be spending all his time taking notes or thinking about what he's going to do that evening.
You also talked a little bit about your 6 years as a managing partner contributing to your I guess perspective is the right word, and has enabled you to approach the resolution of disputes with a fair-mindedness. Maybe you could flesh that out a little bit more for us.
Sure,
Tell us what are
sure.
the kinds of things you learned in that management role that now equip you to do a better job as an arbitrator?
Well, I think there's several things that I would point to, Chuck. One is certainly leadership in running a business of a significant magnitude. A lot of the arbitrations I get are involving businesses, and the witnesses are usually the owners of those businesses, presidents of those businesses, people in high management roles. And so I certainly can relate better, and they can see from my resume that I've had to exercise leadership, particularly during the COVID years, when it was extremely stressful, extremely challenging, and how we navigated through those times and kept the doors open, never reduced people's salaries, never laid anybody off. And so I understand the pressures and the demands that business owners face. And so when they have a dispute and they're engaged in trying to negotiate, or they're trying to resolve it, or they've made a mistake, they're trying to look through it, and I have to make a decision based on the law. They have an arbitrator that's got business experience, not just advocacy experience as a lawyer. So I would say that's number one. Number two
Mhm.
is, I think, working with people who disagree with you, working with people who frankly may not want you to find a good solution. They want to find a solution that fits them, and being able to work with people of different backgrounds who may be your allies on some issues and may not be your allies on other issues, and trying to work with people in a way where their view is just as reasonable as somebody else's view. So reasonable minds can differ in leadership of a law firm, and the ability to come to a consensus, to reach a decision that, while not everybody may agree with, they are, because you can't please everybody, but what you can do is they will see that the approach that you went through to reach the decision that you made included their input and included their points of view or their opinions. And I think they will feel like they were given a chance to be heard. And as an arbitrator, I want everyone to feel that they had their day in court, so to speak, that they had their day in front of an arbitrator. They got to say what they said. I didn't exclude testimony that I thought they really wanted to tell me. I can always assign the weight to it that I feel it's merited based on what the issues are in the law. But I certainly want to give the parties an opportunity to be heard so their input can be considered by me, just like I did as managing partner. So I think those are the top two that I can think of off the top of my head.
Well, you described the fact that when you ended your term of service as a managing partner, you were fortunate to have almost immediately a full volume of client work to engage in. And you spoke a moment ago about having at least another 10 years. I suspect that's being very conservative, Steve. You're a vital, energetic young person with a lot of years ahead of you. So being busy and doing work that you enjoy causes me to wonder why in the world you consciously made this move to redirect your practice towards arbitration and away from the courtrooms.
Well, I think I I go back to a comment I may have made earlier about my father being a judge, my temperament as a listener of evidence, of points of view that I got to be through my managing partner experience. I would probably tell you, Chuck, I wouldn't have been as aggressive in perfecting my arbitration skills if I hadn't served the role as a managing partner. If I had been a trial lawyer, I would have continued on that path, and that would have been fine. But we all reach a point where a change in climate or a change of scenery, if you will, is always good for the mind and the body. And I felt that through that belief, I became a managing partner. And then through that experience, I wanted to transition to arbitration as a way to really leverage my experience as a managing partner and my skill as a trial lawyer to help resolve disputes rather than when I was a young lawyer, which is we're going to go to trial on every issue. Now that may seem like a answer for mediation, and I suppose in part it does, but what arbitration does, I hope, is avoid what I've come to experience as a trial lawyer as I've gotten older, which is the length of delays, the time-consuming and expensive nature of trial work, the uncertainty of the outcome, perhaps in a jury trial system, and more predictability in planning your business, planning your forecasts for the next quarter, the next year, being able to control your litigation expenses by perhaps having some limited discovery, but not necessarily wide open. I think all of those reasons I've come to expect as I've gotten older and a little more gray hair that clients and the public really demand. And I've seen it in my managing partner work, some predictability, some common less uncertain path for our business and the growth of our business. And so I think all of those factors, I think, compelled me to give arbitration my full attention, not completely, because I still have a trial practice, but it got me so interested in, and then I started seeing the success of doing that. And so I've really been now energized even more.
You said that your father had taught you the importance of attention to detail, perfecting your writing skills, and showed you how important it was in the work of the law to communicate in writing. I wonder if you could talk a little bit more about that and how you have found in your arbitration practice written advocacy as either been a strength or something that has needed improvement among the people who are appearing before you.
Well, I think the written advocacy comes in a couple of forms. Traditionally, we think of written advocacy as perhaps briefs that you submit to the court, whether it's the trial court, the appellate court. But I also believe good written advocacy occurs in writing to clients, in writing to witnesses, in writing to third parties. And I think one of the other benefits of having a lot of trial experience and doing, therefore, a lot of written work is you learn that the audience for your writing is not necessarily the person whose name is on the top of the letter or brief that you're sending this written work to. They will share that with other clients. They will share that with business partners. They will share that with other judges, law clerks, whatever. And I think writing with the idea that somebody else is going to be reading this document besides just simply the recipient is very important to appreciate, I think, as an arbitrator. And I think for this reason, when you write a written award, you know the counsel is going to read it for sure. But I think you should always anticipate, and maybe many arbitrators do, but I certainly put it at the front of my brain that clients are going to be reading it, business partners are going to be reading my award. And so I want to make sure that I explain what I've considered, what I've read, what I've heard. I repeat key portions of oral testimony. I cite particular exhibits. I want people to understand that if a party considers a particular piece of testimony very important or written work very important, why I took that into consideration, how I distinguished it or supported it based on other evidence. And I reflect that in my reasoned award so that the party that's advocating that, if I disagree with that, they know why. And so I write that so they can see, they can share it with others, and they can explain it. The counselor just want to go to the bottom line, see who won and who lost. But the parties are really the people I'm communicating my award to. And I want to make sure that they appreciate that I gave due consideration for the evidence that they have presented to me in the course of the evidentiary hearing, and I want to make sure I cite that. I also always tell people that I will write a reasoned award, even if the rules of the particular arbitration hearing do not compel me to do that. Now, I don't have to make it a lengthy award, and there's some people that wouldn't do that for fear that they're exposing themselves to attack, to the award being critiqued. And certainly my job is to protect the award at all costs. And for that reason, I also want to make sure that the reasoned award explains every cause of action, every defense that is being legitimately asserted in the arbitration process, and that I've explained it properly in my award, so that I've protected the award as best I can, and I've given the parties a complete award and not just simply just made a quick decision on who won or who lost.
You were quick to pursue fellowship with the Chartered Institute of Arbitrators, and you not only got that certificate and credential, but you become quite active with that organization. And I wonder if you could share with us some of your experiences with the Chartered Institute and how it has been valuable to you in transitioning your practice.
Well, the Chartered Institute is historically based out of London, but they have various, I'll call them chapters because that's the word that's coming to my mind. And one of the biggest chapters in the world for the Chartered Institute, which is a worldwide organization, is the North American branch. And the North American branch is predominantly the U.S., Mexico as well. There's maybe a few Canadians. So it's not completely the entire North America geographical continent. But I would say it encompasses a majority of the arbitrators who are members of the Chartered Institute that live and work in the United States. They do a number of international arbitrations. That's their whole focus. And there are people that get trained in that and spend their entire life doing arbitrations who have not been trial lawyers. I felt I could add something to the board of directors for the North American branch, not only from my trial experience that I've tried to explain today, but also my leadership in the firm. And so I got to know members of the North American branch. I got to meet people at conferences. I got to meet people in the training who learned about me and who wanted me to join the board for that reason. I think a second reason is we really wanted to develop California's participation in the North American branch, San Diego's participation in the North American branch. And so I was interested in supporting those efforts. I was interested in working with the other board members, chairmen that I've worked with to develop good arbitration community training programs, to support those training programs, to support the mission. I became involved as the editor of the monthly newsletter. I put my heart and soul into meeting other chartered members, regardless of whether they were on the board, and really tried to put my name out there as not just an arbitrator, but somebody who was more than active in the arbitration community, typically the Chartered Institute. And I felt that would help me and has helped me in getting people to appreciate my contributions to the arbitration community beyond simply just someone who writes reasoned awards. When you're in charge of a newsletter, and then we had our yearly conference in San Diego, and I was asked to host that. uh, which I was glad to do with the help of others like you, Chuck, and my staff, who helped me succeed in presenting an excellent conference. I gained credibility in the arbitration community by doing that, even though they know nothing from the newsletter or my conference work or my board of directors work and how successful or effective I write reasoned awards. But they know my hard work and they know how I can contribute through hard work. And that's impressive to them. And that's why if there's 3 judge panels or there's 3 arbitration panels, I feel very confident that that has been a stepping stone for me to gain appointments to those arbitration panels. And that has resulted in that. So I'm very glad I did that. And I certainly encourage all young arbitrators without trial experience, you have to distinguish yourself. You have to differentiate yourself from the large number of arbitrators that could be out there dabbling in it or putting their name out. And I think getting involved in credible arbitration boards where you can distinguish yourself and support arbitration, whether it's Chartered Institute, whether it's CalArb, whether it's any number of these great organizations, you meet people, they get to know you, other arbitrators know you, and certainly lawyers that hire the arbitrators may talk to other arbitrators. Have you ever heard of Steve Cologne? Yes, I have. He's very active in Chartered Institute. He's got a great record, and you should consider him on your strike list. That's what I'm hoping for, and I think that's what I want to continue to emphasize going forward.
Well, I appreciate those pointers, particularly for the benefit of perhaps some younger viewers who may be listening in on this interview. Steve, do you have any other suggestions that you would make to them? And how do you go about building these kind of relationships, cultivating the kind of reputation that's necessary in order to be a success in the arbitration world?
Well, I certainly am a big proponent of being a good lawyer, first and foremost, in whatever expertise in law you want to have, whether it's technology, whether it's sports law, whether it's employment or commercial, like I have. I think law students who go right into arbitration without the benefit of being skilled in a particular area are certainly facing an uphill battle because they've not proven themselves that they understand the issues, that they understand how to evaluate evidence beyond simply the training they may have gotten in law school or in a particular department. And so I certainly would encourage young lawyers to become an expert in the particular field that they see themselves as arbitrators in later years of their career. Sports law, technology has a lot of arbitration agreements, as we all know. Employment has a lot of arbitration agreements, as we know. And I think becoming an expert, like I've tried to explain today, you really do appreciate the issues, the evidence, the credibility of witnesses, and that, if properly channeled into an effective reasoned award, will make you a successful arbitrator. So I personally think that's a path that I would always tell a young lawyer to do. There isn't going to be the amount of trial work that I enjoyed when I was younger to get that level. Certainly, you can second chair trials and you can be part of a team that is in trial, and that is all great. And I certainly support young lawyers. I have a lot of young lawyers on my advocacy team that I give them a lot of opportunity, like the opportunity I was given when I was a young lawyer. I give back to young people. But if those aren't as prevalent, because obviously clients are not as interested in jury trials in 2025 like they were perhaps in the 80s and 90s when everybody had a lot more trials. So if you don't have that, then you still need the skill set of a particular area of law that you can become effective at as an advocate or develop your skills in that area in some way and then becoming an arbitrator or becoming known as an arbitrator within that skill set is just going to make you that much better.
How have you used things like websites, videos, other technology tools to assist in developing your reputation and cultivating a practice as a neutral?
Well, I think you have to invest in marketing of some kind with your own money. And, the firm has a website, the law firm has a website. I'm certainly listed there with my arbitration training, my logos from the various institutes that I've become associated with, the Chartered Institute, AAA. But I have invested my own money in my own website development and my own maintenance of that website. And I decided also to put video of myself on that website. And I think it's important that people get properly channeled there to your website. They can see you talk. You should keep those short, a minute and a half, but you should tell them things in that video about what is your approach to resolving arbitrations. How do you streamline the arbitration process? How do you allow discovery? Do you allow discovery? And you try to not sell yourself, but you try to explain the approach to the process in a way that would encourage people to perhaps put you on or agree that you can be considered as an arbitrator to their clients. Every lawyer has a client to answer to. And so the more information that client can know about you as an arbitrator who's going to resolve their dispute, the better the counsel will feel like they've given their client the right information. So I use technology certainly for website development. I also make use of technology in my arbitration practice. I'm very open to Zoom arbitrations. You do not have to appear in person. I encourage the documents to be submitted electronically so I can keep more accurate rather than have a bunch of paper that's stacked up in my office. I try to use technology because I know that the parties are using it that way. And I want them to feel that the arbitrator is sort of keeping up with them in how they use technology. Everybody is now using technology, and I want to be part of that community of believers in technology. And so I want to encourage them to appreciate that I will be using the same technology they will be. And I ask them at the preliminary hearing conferences how they utilize technology and what I can do to help facilitate ease of transmission of documents, ease of presenting witnesses, because that keeps costs down. And as I've tried to explain, my goal in appealing to the parties, it's costly to be in litigation, even arbitration litigation. And so the ways that I can do using technology, however, I haven't been able to quantify this, but if I could use it to streamline the cost of litigation, I want to support it.
A comment, if you could bring out your crystal ball for us. I wonder if you'd share with us your visions of where this arbitration practice in California is going, and particularly the opportunities that are opening up for international arbitration as well.
Well, I think it's very exciting. I think for the reasons I started to say earlier, I think the jury's trial system is cumbersome. I think it's complicated. I think it's expensive and uncertain. And I think for all those reasons, I think arbitration is going to be an effective forum for people to appreciate and to come to utilize. And I think you're going to see more corporate transactional lawyers write arbitration provisions more carefully in the transactional documents to allow the parties perhaps to have freedom to decide a lot of issues in the arbitration process. So I think that is going to happen. And I think for international arbitrations, I think there's certainly going to be exposure for arbitrators who are bilingual. For me, I can speak in San Diego. There's going to be a lot of people investing in California, investing in the United States from Mexico, writing documents to that effect. I think California is still considered a top-notch place that, with all the people we have here, that transactions are still going to happen and arbitrations are going to be part of those. So I think you have to think in terms of not just for the arbitration future, in terms of arbitrators' work and experience. I think you have to look at, well, what are the parties doing in advance of the dispute to make certain that arbitration has a future? Are they writing arbitration in their international documents? Are they writing what issues are they allowing to be discussed? Is it all issues except for class action waivers, or is it limited? And I just think you see more and more people take advantage, and I want to be at the center of that when the disputes arise. And right now, I feel with my experience, I'm pretty unique in enabling myself to be available for parties and arbitrators who have 3-judge panels to select me, and I'm very excited about that. So I do see my personal practice in arbitration growing from 30% to perhaps as much as 70 and even 100% in the coming years. And I do like that law schools are developing arbitration programs, international programs. USD in San Diego, University of San Diego, has a very effective international arbitration. They're giving young people that kind of training in law school, which I never enjoyed or saw when I was in law school in 1981 to 84. And so I do think more schools are going to have that. They're going to develop those curriculums, and they're going to promote that as part of a great legal education. So not just for young people in arbitration, but I do think parties will also see a growth in arbitration experience.
Well, Steve Cologne, thank you for taking your time to be with us today. This has been a rich and very informative interview. I think our viewers will at the end be very pleased that they've had an opportunity to learn from one of the masters, if you will, to take some of your practical suggestions. We're grateful for you helping us with this California Conversations series. And I am really, on behalf of CalArb, most grateful for your, as I said, taking the time out of your schedule today to be with us.
Thank you, Chuck.
Wishing you the very best for the time ahead, and thanks again.
Thank you, Chuck. Pleasure to be here.